Pakistan's Supreme Court has begun hearing review petitions challenging its earlier ruling that allowed PTI to claim reserved seats in the National Assembly. The July 24 verdict had declared nearly half of 80 listed MNAs as returned PTI candidates, making the party the single largest in the Assembly. But the ruling has remained unimplemented, with the Election Commission and rival parties raising objections. Now, a full 13-member constitutional bench is reviewing the case. On Monday, two judges, Justice Aisha Malik and Justice Akil Ahmed Abbasi, called the review petitions inadmissible. But the majority disagreed, issuing notices and adjourning the hearing until Wednesday. The petitions were filed by the PMLN, PPP, and the Election Commission. Their argument? That PTI wasn't a party to the case, its ally, the Sunni Ittihad Council, was. The PTI, they say, never directly approached the courts for these seats. But Justice Aisha pointed out that the issue had already been addressed in the court's detailed verdict and questioned the grounds of the review. The ECP argued that changes to the Election Act amended after the verdict should impact the ruling, but the court had earlier clarified that those amendments couldn't override the July judgment, especially when applied retrospectively. Meanwhile, the Supreme Court is also handling related cases, PTI's challenge to the election law amendments, and a separate plea over the denial of its election symbol. In a related judgment earlier in the day, Justice Mansoor Ali Shah, who authored the original reserved seats verdict, reminded that review petitions should only be entertained when there is a clear, self-evident error. Simply disagreeing with a ruling isn't enough. The court also warned that frivolous petitions are clogging an already overburdened judiciary, with over 56,000 cases currently pending at the Supreme Court alone.